good evening, good afternoon, whatever time it is in your time zone. It's great to be here with you. We'll get going here in a minute as we're admitting people. Thank you. Well, today is, I'm so confused on my days. It's been such a busy week. Today is December 14th, 2023. And we've had Hanukkah here and Christmas is coming up, and the holiday spirit is in great, is being greatly exhibited, hopefully. And we have a full house for our last presentation of the year. And so it's so nice to be here with you. As you know, these Will Work for Food New Possibility Hour presentations are provided by a wonderful colleague, a fantastic presenter, and they generously donate their time. We also have such a generous and amazing community, Will Work for Food community. I know it's thousands of people who get the email every week telling about the programs. And then the donations, there's no charge, as I had said, but we ask for donations to a food bank, either of your choice or for the suggested food bank of the speaker. And, you know, we've been grappling with that question: who's going to be the speaker that's going to put us over $500,000 in donations, having dated back to the spring of 2020 when Natalie Armstrong-Motan founded it, thanks to the pandemic and wanting to make a difference in the world. And you've all made such a difference, millions of meals so far. So thank you so much for that. Now, where are we today, Jeff? Do you want to tell us the number? Go with your drum roll. You love this part of the presentation.
Da, 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 da. Thank you, Jean. I'm so happy to announce that the running total of contributions from our generous audience members in honor of our great speakers is now at $499,186.93. We have a nice big audience today. So Katherine Simpson, congratulations at Trivia Contest Games for the rest of eternity. You will be known, Dr. Katherine Simpson, will be known as the speaker who put the Will Work for Food project over the $500,000 mark. Thanks to you, Katherine. Thanks to all our great speakers, our generous audiences. Natalie and Jean, thank you so much. Back to you, Jean.
Oh, thank you. This is great. You know, I do want to say a special thank you to Jeff Kachavin, the co-moderator, and Natalie Armstrong-Motan, being that it's a season of gratefulness here, for having founded this, for having gotten it going. And Jeff works so hard every day, practically, it seems like, looking for speakers, as do I. But Jeff, thousands of emails from Jeff thanking people and inviting them. So it's just wonderful to have you all here. Thank you for being you and for being here. And now I'll make one more ask of you before we get into today's program. And that would be, you know, Jerry Lewis has that telethon. How about if we do that today? And if you can make a donation in any amount to either the food bank that Dr. Simpson will talk to us about, or the food bank of your choice, and then do in the chat to Natalie, to Jeff, or myself. We'll add that up and we will be over the $500,000 mark today, live, during this performance, during this presentation, I should say. And then there'll, of course, be more to come for the end of the year. But thank you all. So let's get down to it. Today, we have an interesting program for us all on diversifying ADR. And this program will review the many efforts underway to increase diversity in ADR. And of course, diversity can take many shapes and forms. So it will be very interesting. We have Dr. Katherine Simpson here to present to us. She is an arbitrator with the broad dispute resolution practice. She is a fellow of the College of Commercial Arbitrators, where she also serves as co-chair of the Diversity Committee. She is vice chair of the board of the Ray Corollary initiative and is chair of the Women in Dispute Resolution Committee of the ABA Dispute Resolution Section. Dr. Simpson teaches conflict resolution and management at Cornell University School of Industrial and Labor Relations. She heads Simpson Dispute Resolution in Ann Arbor, Michigan, and is an arbitrator with 33 Bedford Row Chambers in London, the UK. So we have great diversity right there in Dr. Simpson's background. Would you please tell us then, Dr. Simpson, a little bit about your preferred or suggested food bank, which is All for Lunch and Lunch for All. And then the floor is yours, and we look forward to hearing what you have to say. Thank you.
Well, thank you. Thank you. Thank you so much for allowing me to be here today. All for Lunch and Lunch for All is a program where you can donate to help buy an elementary all the way up to high school students lunch, or help to erase their school lunch debt. This is a charity that operates in a number of jurisdictions, so you can choose to sponsor the schools closest to you, or you can choose to sponsor the schools where there's the greatest need. Making sure that children are not hungry during the school day has just numerous social benefits, and enabling children to have lunch confidently is simply important. And I hope that we can all join together today in supporting this organization and helping to eliminate school lunch debt. Well, I suppose this is where I'm supposed to start my presentation.
Feel free. Yes,
Feel
yes.
free.
Thank
Okay.
you.
Well, today I'm talking about diversifying ADR. And the presentation goes from this premise. Diversity is a problem in alternative dispute resolution. Diverse neutrals are simply not appointed as much as they would be in a space that ensured open, fair, and skills-based competition. And fortunately, this problem is completely remediable. So I'm going to share my screen because this is one of my favorite slides that I use when teaching. We've all seen something like this before, this idea that the pool of potential candidates has been very limited, and there's a general unevenness in the quality of candidates. And when I first saw this quote from this particular source, I admit I hit the ceiling. But as I read on, there was simply more to it than that. This quote is not about diverse neutrals. This quote is about everyone who was appointed to the U.S. judiciary before 1978. Before President Carter initiated what many refer to as his other human rights record. He recognized that this network-based who knows who means of appointing people to the judiciary was simply not ensuring that people who had the skills and expertise to be there, it simply was not working. And he changed the way that America appoints its judges, creating an application and appointment-based process that focused truly on the merits of the candidate. And when he did that, in addition to expanding the judiciary by about a third, he managed to appoint more women and more persons of color than had all prior presidents combined. And, I think it's interesting that in 2023, arbitration and mediation really finds itself in a position that the judiciary was in 1978. And we are fortunately in a position to change that. So for my presentation, I think it would be wonderful if you could put your questions in the chat, and then I can address them as I run out of air. But as you do that, I would like to make one disclosure, which is that I have just a teeny tiny bit of paralysis in my face. And so my right eyebrow, I can raise it and lower it about 3 times a day. And after that, my eyebrow doesn't like to lower on its own, and I have to give it a little bit of a manual letdown. But as a result, I sort of look perpetually skeptical, intrigued, quizzical, you name it. My eyebrows do not communicate. Let's just put that out there. You can put your questions into the chat, and you may see me lower my eyebrow, but it's something I have to do all day, every day, especially once I start smiling. Eyebrow goes up right along with my cheeks, and I kind of have a rubber face like Jim Carrey in The Mask. So now that we've got all of the disclosures out of the way, I'd like to start off with a little bit of myth busting. After that, I think that we will move into approaches to improve and increase diversity in ADR. And finally, and as we're working through the approaches, we'll really look toward the front end approaches, increasing the number of neutrals, but also the back end approaches, making sure that neutrals are actually being appointed. And then at the close of that, we will explore some of your questions. So moving on to myth busting. Why is diversity important? I want to disclose the first kind of myth or assumption on superpowers, or rather disclose my own belief. I don't believe that any gender or ethnic or racial group has any special superpowers that make them resolve disputes differently than anybody else. And that's why we really need to be looking at ADR as a whole and recognizing that we need to have the best arbitrators, not simply the best white arbitrators or the best male arbitrators or the best female arbitrators or the best arbitrators of color. We need to have the best arbitrators. And likewise, in similar comparative form, we need to have the best mediators. We need to find a way to be using all of the talent that is available in alternative dispute resolution, not simply the best senior talent, not just the best white talent, not just the best female talent, and not just the best male talent. We need to be using all of the available talent. And why? Well, because this is an idea that many of us have been raised on, that full competition, whether it's competition between products or competition between ideas or competition between people, competition enables the best ideas to come forward. It enables the best practices to come forward, not just the best confined in a very narrow window, constrained by gender or sexual orientation or ethnicity or race. We need to enable the best to be able to come forward and shine. And in a way, that here's the fire and brimstone to that, is that our discipline, I struggle about calling ADR an industry, but our field of practice really depends on this, because competition, full, fair, robust competition, is something that we understand as promoting trust. We also understand it as being sustainable. And frankly, we need this, in particular for the sustainability of ADR, because it's been estimated that ADR could be facing a major demographic shift in the next 5 to 10 years. Many arbitrators, some would suggest the overwhelming majority of arbitrators, are over the age of 70. And in the next 5 to 10 years, they could all be retiring from ADR en masse. And we need to ensure that arbitration and mediation are already able to use the full, highly qualified array of talent that is available, talent that will be absolutely necessary to fill this gap in the next 5 to 10 years. We need to be taking practices now to improve diversity so that this system that we have, a system that supports court systems, so that our system is sustainable in the next 5 to 10 years and can continue providing service to everyone who needs the benefit of ADR. Another myth that I'd like to go into a little bit, I suppose it's not really a myth anymore given the recent Supreme Court rulings, but I think it needs to be clear that not everybody actually supports diversity. Diversity represents a significant change in how people operate their practice. Many current and aspiring neutrals have planned their careers around this idea that their competitive space will be shaped in a certain way. Maybe there will only be one seat at the table. Maybe they are only competing over these seats at the table. And actually creating a system where everyone has the opportunity to compete for every seat at the table is a major practice and professional upset to many people who are currently practicing ADR. So I don't think it is fair to assume that everybody is actually in favor of increasing diversity in ADR, despite the benefits that I personally believe in, that are clearly supported in economic and social science literature, that diversity has to give. But another reason why people often don't really support diversity is that they argue that this is a fool's errand. There simply aren't any diverse neutrals. And that actually takes me into one of the approaches for supporting diversity in this space, which is simply making a list. The fastest way to disprove the myth that there are no diverse neutrals is to make a list and prove them wrong. And in 2020, on Pandemic Eve, well, not quite Pandemic Eve because it was January, but Pandemic Eve for my purposes, I noticed that the European Union and Canada, in their comprehensive economic and trade agreement, had failed to appoint any women to the chairperson's roster. And in response, I made a list using the treaty requirements of what skills and training would somebody need to have to be a trade treaty arbitrator and chairperson under their treaty. I created a roster, first alphabetical, with the consent of all of the women, of 70 women who could replace one or more of the men who had been appointed purely on a skills level. The alphabetical list was published, and the list that literally matched each woman to the man or men that she could replace remained confidential and in the hands of only the Canadian authorities and authorities with the European Commission. It disproved the myth and idea that there are not any women active in or interested in international trade law. And in response, the European Commission created a cross-institutional panel and fundamentally changed how they appoint arbitrators. Rather than having, like in the United States pre-1978, rather than having a process where people who knew someone or knew somebody were getting appointed, they created an application-based process. And through that process, expanded their back roster. I estimated that their back roster of potential arbitrators was only 43 people. Now, thanks to this public process, they have 390 people who are eligible for appointments to their international trade rosters and investor state rosters. This simple action of diversity increased the opportunities for appointment nearly tenfold. And that's something that we have diversity to thank. If there had not been a recognized need for diversity and for changing how arbitrators are appointed, the European Commission would not have needed to take these steps. And diversity increased opportunities for everybody. So the rising tide lifts all ships argument. And following that, Nancy Thevenin from the USCIB and I decided to create the Arbitrators of African Descent roster, or list. It was made in response to this idea of there are no Black arbitrators. We created a roster that had 124 individuals who were ready, willing, able, and fully trained and experienced, who were interested in taking international commercial cases that had a connection to the United States. At its end, this list had more Black arbitrators than there were Black lawyers working at the top 50 international commercial arbitration practices in the US. It completely dispelled the myth that there aren't any. Now, those making a list, and there are lots of lists available. There is the Blacks of the American Society for International Law. There's the Directory of Black Arbitrators on arbitrate.com. Arbitrate.com took over the Arbitrators of African Descent project. There is the Women in Dispute Resolution roster, which is put together by WIDER every year. There's the membership list for arbitral women. There's the Compendium of Unicorns, which pulls on the idea. It was somebody said to Lucy Greenwood at a conference, talented female arbitrators are not, they're like unicorns, they don't exist. Many groups have adopted that unicorn language to say, actually, we do exist. Now, making a list is wonderful fun. Unfortunately, lists are generally outdated, maybe within 30 seconds of publication. And they don't actually do anything for increasing the number of people in the space or necessarily for increasing appointment, although they may help. They do help in busting the myth. But one space, there are front end and back end projects. Front end increasing the numbers, back end increasing appointments. Not the most artful language, but it's what I have. Other front end projects include scholarships, actually making it more financially feasible for people to get the training that they need to become neutrals. Mentoring projects now available through a number of organizations. These recognize the sincere network-based operation of many parts of ADR and encourage people who are established in the space to bring additional neutrals into the space, providing them really everything that a solid mentor would, whether it's advice on business development, on drafting, on panels to join, on panels to forget. These mentoring programs are very helpful and offered by a number of organizations, including the College of Commercial Arbitrators just established its associates program. Excuse me. On the back end side, though, what we have is ensuring that the neutrals who actually have all of this training and who are ready to receive appointments, that they are actually getting appointed. And that is why I work with the Ray Corollary Initiative. We're all familiar with different spaces that say that 30% is the number that is needed in order for diverse candidates to actually have an opportunity at hiring. We know this through the Mansfield Rule. We also know this from a study at Harvard. They studied higher education employment interviewing and found that if the final slate of candidates only had one diverse candidate, and regardless of the percentage of people in that final slate, if they only had one diverse candidate, there was no chance that that person was getting hired. Yet, if they had at least two diverse candidates in the final offering, and if those candidates made up at least 30% of the people being considered, then the likelihood of a diverse candidate actually being hired was greater than their representation on that slate. So if you met the 30% metric, the likelihood that a woman would be hired was 50-50, greater than her representation on the slate. And for African Americans, the numbers were even bolder, where if you hit that 30% metric, you were looking at upwards of a 70% likelihood that one of the African Americans on the slate would be chosen. And there are several theories for this. One of them being is that when you hit 30%, the diverse candidates become viewed as being part of the status quo. Their credentials are not dismissed or degraded as being somebody fulfilling some sort of requirement or some sort of optics. Instead, their credentials are reviewed and appreciated, and they are viewed as equally part of the hiring pool. And with the Ray Corollary Initiative, we are encouraging everyone who appoints arbitrators, including and especially arbitral institutions, to ensure that when they send an appointment slate to parties who are going to be ultimately making that appointment, that they ensure that at least 30% of that slate is diverse as defined in ABA Resolution 105. And the International Institute for Conflict Prevention and Resolution was the first institution to adopt the pledge, and they made their own consistent pledge for different members of their community. This spring, JAMS adopted the RCI pledge so that when people have a JAMS clause in their contract and JAMS is proposing arbitrators, JAMS will ensure that at least 30% of every slate that they put forward is diverse. And likewise, the American Arbitration Association, one of the first things that Bridget Mary McCormick did when she joined JAMS was to push the AAA to adopt the Ray Corollary Initiative pledge. And so far, we have anecdotal evidence from the AAA and also the CPR that this has been working to dramatically increase the likelihood that that diverse candidates are being considered and also appointed, transforming ADR into a sustainable career option for diverse candidates. And this is really a wonderful, wonderful moment for us, because you know, when it's time in the next 5 or 10 years for this so-called next generation of neutrals to be really taking the stage in the wave of, you know, the pending retirement of many people who currently occupy these spaces and the majority of appointments, diverse candidates will be ready and fully experienced, having now been able to spend the coming 5 to 10 years assembling the experiences that we're going to need to be able to carry this this profession forward. Another space where increasing appointment opportunities has come forward is in Meet the Neutrals events. We've all, I think, I can't really see everybody's hands, but so I'll just raise my hands for everybody. Raise your hand if you've ever been to an ADR conference where everybody is just shelling out business cards left and right into the air, hoping for the opportunity for an appointment. I see my confession zone. Thank you. I've been to these too. And what several organizations have started doing, the Ray Corollary Initiative, the Equal Representation in Arbitration Pledge Initiative, and even the AAA and the National Academy of Arbitrators, we have started putting on Meet the Neutrals events. One of the criticisms, and maybe I should have included this in the myth busting, next to the there aren't any, there's the, well, but we don't know any. These events change that. These are speed networking, similar to speed dating, but it's really speed networking. Speed networking events where we start maybe with a small presentation and get people primed to meet one another. We distribute questions that people could anticipate both to the neutrals and to the potential appointers. We have some snacks together, and then ring the bell. It is time to start doing speed interviews. And depending on how much time we all agree on, every 7 to 10 minutes, the bell rings, the partners change, and people are getting to know arbitrators whose CVs have never crossed their desks before. Arbitrators are getting to know institutions and institutional appointers who they had never considered to be as part of their professional radar. And at the end, we close this off by publishing books of CVs, and really every group is doing this, which is great that we've kind of all got a standard operating procedure together, although we've never coordinated it. But we publish books of CVs so that every attendee, they're going to be walking out with the CVs of everybody who they met or who they could have met. And this has been a lovely opportunity, really, for, I think, improving transparency within ADR. Because now, thanks to these events, people can honestly say, I met this arbitrator at this event, rather than saying, well, this arbitrator is part of my extended network, but we don't necessarily have any conflicts to disclose. It's expanding people's network in a trustworthy, transparent, and sustainable way. And many of us, we go to conferences so that we can meet one another, and also so that we can meet people who are potentially going to appoint us in the future. This directed networking style of event helps us do that, so we can pay attention to the presentations when it's presentation time, and pay attention to the networking when it is networking time. Another approach, and I think that this works as both a front-end idea and a back-end idea, is to increase the publication of the relevant ways that people join panels, and also to increase, and this is more for institutions than anyone, to increase focus on the relevant experience that one needs to join a panel. So I'll start with making the entry requirements more transparent, sustainable, or even direct. Many of us, show of hands, how many of us have wanted to join a court panel as a court-appointed mediator or a court-appointed arbitrator? And when you look at the requirements, most courts have different requirements, and one court's 30-hour mediation training might not meet the requirements for another court's 30-hour mediation training, which is different from another institution's mediation training. You get this, I call them Scooby-Doo clues. You get this clue on how to join a panel, and it turns into a very winding mystery path of how do I find the right course that will at least meet the requirements of 3 or 4 other institutions. And do I really need to take another class for something that I've been doing for 10 years? I think that all of our organizations need to work more with the institutions to really get down to the core of what is it and how is it that I need to be trained in order to be able to offer my services under your flag. And making these opportunities and experiences more transparent, more easily mapped, will enable more people to enter and thrive in a space that absolutely needs more mediators and more arbitrators. And in addition to that, I hope that institutions will continue to place a focus on the experiences that are absolutely relevant to performance as an arbitrator or as a mediator. How many of us, I like shows of hands, have heard that you need to shadow an arbitrator or a mediator, or work as a tribunal secretary, or work as an associate arbitrator? An associate arbitrator is like a tribunal secretary, but for labor arbitration cases in the US. Many of us have been in that space. And when, for example, when you're a tribunal secretary, you get to be in the hearing room. You get to be in the deliberations room. You get to work with the arbitrators as they are putting together their proposals for that essential procedural order number 1. You get to listen firsthand to the experts discussing why we are doing document production after the first round of written submissions rather than before the first round of everything. Or you get to work with people as they are developing a virtual hearing protocol that will ensure everyone due process. And yet, the tribunal secretary experience is one of the only purely relevant experiences for arbitration. Whether it is labor arbitration, commercial, or consumer, it is one of the only experiences that is not expressly recognized as relevant experience when one is attempting to join different arbitration panels for the major institutions. There are some institutions which offer their own tribunal secretarian courses, which are wonderful, but they don't necessarily help somebody on their path to becoming an arbitrator without a little more. And, you know, the ICA found in 2020 that the tribunal secretary space was the space or level of arbitration that had the most diversity. It had a majority of women and a majority people of color. And yet that experience space is not recognized as much as the experience of being a low-level attorney doing document review in support of an arbitration. We can change this. We can help institutions understand the importance of different kinds of experiences for one's future arbitration practice. And once all of these truly relevant experiences are recognized, I would expect that there will be even more diverse neutrals joining and thriving in this space. Because once the experience is recognized, you know, it adds on to your years of experience. Now, I see one question in the chat. Are the RCI results or outcomes measurable? Yes, they are. They are because each institution has a before and an after. And while we don't have measures yet for this year, we only have anecdotal evidence of institutions saying, wow, this has helped us move the needle, increase the appointments. This has helped us expand our rosters. At the moment, we only have anecdotal evidence, except the CPR did put together a presentation showing that when they were able to meet the RCI's 30% metric in all except for one of their cases last year. And I see that this is being recorded and I can't remember the exact number, but that their appointments of diverse neutrals was well over 30%, that their results were actually consistent with the results out of the employment hiring context, which, you know, is completely differently regulated. We're hoping that with others who have now joined the Ray Corollary Initiative, including Resolute Systems, that we will be able to actually measure how and whether the RCI is changing how and whether people are appointed. But is it measurable? Yes, it is. Do I know the measurements right now? No, I don't. But you know, we've got a few days left in the end of this year where we can begin the measuring. I see. Oh, and Lisa Romeo, who's a vice president of the AAA out of Boston on their complex case panel, has put into the chat that prior to signing the RCI, the AAA required 20% diversity on their lists that would go out to parties. And you know, by adopting the Ray Corollary, and this is my statement, not Lisa's, just so that we're clear on the citations. By adopting the Ray Corollary Initiative pledge and moving from 20 to 30%, that was actually a 50% change in their diversity goals and requirements. I've heard lots of great things from the AAA, and I really look forward to working through the numbers with them on what kind of an impact this would have. Another part in the chat: what do you suggest for someone newly trained in mediation to break into the business without a law degree? Fortunately, this is a space where one can have a thriving practice without a law degree and without a law license. Unfortunately, at the same time, this is a space where one does not need to have a license. And I say that because there's such a comfort in licensure and certifications. You can go to your task list and check off, I have this certification, I have this license, I'm ready to go and hang up my shingle. In ADR, it's simply not the same. And so you have to figure out where you want to be mediating and where you want to be arbitrating. And for the moment, find out what the explicit and implicit requirements are for each. It is very difficult. And like I said at the outset, it's like you've got this little Scooby-Doo clue, and it's going to take you on a journey through, whether you're in New York and you have to do Part 146 training, whether they will accept the Chartered Institute of Arbitrators training, whether you need to join an institution in order to take their training, or whether there's another private sector organization whose training will be accepted across a number of jurisdictions. There are different organizations that may nonetheless be helpful. The American Bar Association Dispute Resolution Section, for example, has 19 committees. You can join all of them for one fee. That's what I did. And people there can advise you on which courses to take and which trainings to do, and how to meet people who can help you advance your career. I'm sorry that I can't give better advice than that one. There's another question. What do you think could help ADR panels, directories, or organizations to decide to remove eligibility requirements for applicants to be on ADR panels, to be former judges or 20+ year litigators, especially like where organizations like the ABA show that more than 85% of women of color leave the law by year 7 due to biased statistics. And this shows the vast underrepresentation of attorneys with disabilities in the legal field, and that not all ADR practitioners are attorneys. What could help remove the barriers to ADR practitioners under 40 to be assigned to cases? First, I mean, not to make light of it, I think it's very helpful to have white hair like I do, which I confess I started growing at the age of 5. I am just barely over 40. And I tell people that it really takes about 5 years to get your feet firmly grounded in ADR, in arbitration and mediation. It is not as speedy as putting up a shingle as a lawyer. That said, many of the eligibility requirements for applicants to be on ADR panels, the ones especially that require 15 or 20+ years of experience, I encourage people to go to the panels that they want to join and ask, what do you mean by 20 years or 15 years of experience? Because oftentimes 15 and 20 years of experience are a pronoun, because many institutions assume that by 15 or 20 years of experience in litigation, for example, this person would have spent at least 2,000 hours in the courtroom, or they would have had 500 cases under their belts, or they would have participated in X number of contentious cases, multi-party cases, and most of the time, institutions are eager to share exactly what they mean by that. Many institutions operating in a space where there is not express or explicit licensure are trying to ensure that the people who join their panel truly are experienced enough to run a process that affords everyone the confidentiality that they want and the due process that they deserve and are required to be given by law. And many institutions will tell you, we want people to be fellows of the Chartered Institute of Arbitrators because that testing shows that the person is able to complete an arbitration award in an enforceable way. Others will say, we are looking for people who actually have 3 to 5 years of experience mediating court cases on any variety of courts. Or they're even looking for people who are already members of 2 or 3 organizations. I have seen the panels that and directories that limit themselves to former judges. But what I've also seen in the last 5 years is that several of those have now expanded and include non-lawyers and highly experienced mediators. So I hope that that wasn't a too roundabout way of answering the question. And I hope that you do stay in ADR because, frankly, not every case wants to have somebody who is a retired judge. After all, they have chosen ADR because they don't want to have a judge on their cases. And if you're not a retired judge, great. Neither am I, neither are half of the people in this room. And there are cases out there for people who are not retired judges. And I hope that that's a fun takeaway on that. Oh, wow. I just saw in the chat that we're $75 away from the $500,000 mark. So thank you, Jean, for posting that. And I'm sorry I haven't scrolled through the questions as much as I would have liked to. But I do think, and I'll come back to mentoring and the tribunal secretary experience. I do believe that, and this is perhaps because I'm biased and perhaps because I'm right, sometimes the two go together, that the tribunal secretary or the associate arbitrator experience can be an unparalleled opportunity to learn your way into the ADR field. And sometimes it takes 2 years to get a call back. I once pitched my services as tribunal secretary to an arbitrator and was told I would never, ever hire a tribunal secretary, but I'll take your card anyway. And 2 years later, the phone rang. Sometimes it takes a little patience or a lot of patience. 2 years, I suppose, is a lot of patience. But if you can find a senior arbitrator who is willing to work with you for pay, for you to work with them on their cases, it is a wonderful introduction to the full practice of arbitration. Now, my bias is that I started in this field as a tribunal secretary to a senior arbitrator about 13 years ago. I worked with Karl-Heinz Bruckstiegel on his cases for about 10 years. And it was the best introduction I could have ever had. And he allowed me to turn that into a business. My business started as being tribunal secretary to a variety of arbitrators in cases that were valued at over 50 million. And then when I returned to the United States, I began to broaden my practice, because it turns out that the skills that you need in international commercial arbitration are a heck of a lot like the skills that you need in labor and employment arbitration. And I expanded my practice to include both. And in both cases, I started by working as a tribunal secretary, or in the labor case, as an associate arbitrator governed by Section H of the code, to assist senior arbitrators on their cases before taking on my own as an arbitrator. And it has been wonderful, and I would encourage anyone to try to pursue that path. Now, I did not make a fancy slide on how to reach me, unfortunately, but I'll share the screen. You can find my profile now on the College of Commercial Arbitrators website. And this has a kind of a summary of my case experience. And if we scroll down, you can have my email address and reach out really whenever you would like to, and we could discuss some career strategies if you like. Also, as chair of WIDER, I try to put on a practice building lunch every other Tuesday, where we invite appointers, whether groups of attorneys that have thriving ADR practices, or leaders of arbitral institutions and other rostering entities, to actually come to the group and say, what do you mean by 20 years of experience? How do I really join your panel? If I have this much experience in insurance law, but I'm not a lawyer, do I still have a chance at being a part of your roster? And this has helped many women and many men. Frankly, there are lots of men who are now members of WIDER, the Women in Dispute Resolution Committee, to join panels that they previously believed were out of reach. And if you have an idea of a panel that WIDER could be putting together, please let me know. I would love to work with you on that. And I see in the chat that we broke $500,000.
Yes,
Thank
we
you so
did. Oh, thank you, Dr. Simpson, for your presentation and for making yourself available to everyone. What a wonderful holiday gift to all of us. And thank you, everyone. You know, that's millions and millions of meals. Unfortunately, there's hunger in the world that we're not able to solve, but we're able to make a difference and help a little bit. So, Natalie, Jeff, did you have anything you wanted to say?
Thanks, Katherine Simpson. Thank you for a wonderful presentation. Thanks to all the many people who are here listening and contributing today. All of our great speakers over the past nearly 4 years. Natalie for organizing, founding the Will Work for Food project, Jean being such a great partner and everything. Thanks to everybody.
What a great team we all make. So that's a wrap for 2023 for Will Work for Food, the New Possibilities Hour. Thank you again for being the wrap-up speaker, Dr. Simpson. And we will see you all January 4th, Thursday, same time, different Zoom link. Thank you so much. Have a wonderful holiday season. All the best to you and your families. Bye-bye.
Safe holidays with a hope for peace.
Yes, thank you.